My learned brothers and sisters, this is Advocate P. Devarai talking to you from Ahmedabad city, Gujarat state, India, that is Bharat. Today I have selected a very good topic from criminal law, and the topic is substantive evidence versus corroborative evidence. I will discuss number of sections of BSA Section Adhiniyam 2023, sections 54, 55, 57, 58, 59, 160, 148, and Bharatiya Nagarik Suraksha Sanhita, that is BNSS 181 and 183. And I'll just discuss everything in this topic. The first question is, what is the meaning of substantive evidence? The evidence offered to support a fact in issue as to the necessary elements of the case, as opposed to evidence that is to procedural or collateral issues. Oral evidence means testimony of living persons, including deaf and dumb. Oral evidence means the testimony of living persons examined in the presence of the court or commissioners appointed by the court. Deaf and dumb persons may also adduce evidence by signs or through interpretation or by writing if they are literate. All facts except the contents of documents or electronic records may be proved by oral evidence. Here we are talking about documents, proving documents. Document speaks itself but doesn't prove itself. So the contents of the document can be proved by oral evidence. Arises. What is the difference between substantive evidence and corroborative evidence? The meaning of corroboration is to support with evidence or authority to make it more certain. It confirms or supports other evidence. Corroborative evidence is evidence that strengthens or confirms already existing evidence. In course, it is used to support the testimony of a witness. Corroborative evidence is a collection of facts and information that backs up someone's story in a court of law. Corroborative evidence is used to upheld. Now, BSA Section Adhiniyam 2023, first I will tell section 55. That is very important for oral evidence. When a witness appears in a court of law to give his testimony by appearing in witness box, what should be the quality of his testimony? It is discussed in this section 55 of BSA. Section 55 reads, oral evidence to be direct. Oral evidence shall, in all cases, whatever, be direct. If it refers to a fact which could be seen, it must be the evidence of a witness who says he saw it. A fact which could be heard, it must be the evidence of a witness who says he heard it. A fact which could be perceived by any other sense or in any other manner, it must be the evidence of a witness who says he perceived it by that sense or in that manner. An opinion or to the grounds on which that opinion is held, it must be the evidence of the person who holds that opinion on those grounds. Now, my all learned friends who are conducting trials knows it well that when doctor is summoned by the court and appears in witness box, when he discusses about injury report, thereafter we ask him about his opinion. He's not a God. Whatever he says is not gospel truth. When he gives the opinion, it is our duty to ask him grounds for his opinion. It must be scientific analysis. Then his opinion can be accepted. Oral testimony. What is the scope and application of it? This is also very important while conducting the trial. Generally speaking, oral testimony may be classified into three categories. Number one, the witness must be wholly reliable. Number two, a witness is wholly unreliable. And third category is witness is neither wholly reliable nor wholly unreliable. These are three categories. Oral testimony requires further corroboration from reliable testimony. It can be direct or even circumstantial. It could be thus seen that in the category of whole reliable witness, there is no difficulty for the prosecution to press conviction of the accused because witness is wholly reliable. And it is the quality of the evidence that matters, not the quantity. Even on the evidence of one witness, if he is a sterling witness, there can be conviction and punishment. Now, second category. In case of wholly unreliable witness, again, there is no difficulty in as much as to acquit the accused because it's 100% false, his evidence is. On the basis of oral testimony provided by a wholly unreliable witness, straight away, accused can be acquitted. Now, the third category, neither wholly reliable nor wholly unreliable. The real difficulty comes in case of the third category of evidence, which is partly reliable and partly unreliable. In such cases, the court is required to be circumspect and separate the chaff from the grain and seek further corroboration from reliable testimony, direct or circumstantial. Such evidence requires unimpeachable corroboration. Primary evidence versus secondary evidence. Primary evidence is the best evidence only when it is lost, secondary evidence is allowed. If you have lost original, then you can apply before the court for adducing secondary evidence. If court permits, you can. Section 57 of BSA Section 2023 defines primary evidence. Primary evidence means the document shall produce for the inspection of the court. Section 58 of BSA Section defines secondary evidence. Section 63 of Evidence Act, Indian Evidence Act 1872, deals with the secondary evidence and defines what it means and includes. And BSA 23, Section 58, deals with secondary evidence. Secondary evidence includes, as per Section 58 of BSA, certified copies given under the provision hereinafter contained. Copies made from the original by mechanical processes, which in themselves ensures the accuracy of the copy, and copies compared with such copies. Third, copies made from or compared with the original. Fourth, counterparts of documents as against the parties who did not execute them. Fifth, oral accounts of the contents of a document given by some person who has himself sent. And the last, sixth one, oral admission. Section 59 and 64, 69, Section 59 of BSA and Section 64 of Indian Evidence Act deal with the same thing, that is proof of documents by primary evidence except in certain cases mentioned above. Once a document has been properly admitted, the contents of the documents would stand admitted in evidence. And if no objection has been raised with regard to its mode of proof at the stage of tendering evidence of such a document, no such objection could be allowed to be raised at any later stage of the case or even in appeal. So you have to take objection for the mode of submission, or the mode of accepting the document in lower court itself. Oral evidence versus documentary evidence. BSA Section 54 and Evidence Act Section 59 states that all facts except the contents of document or electronic records may be proved by oral evidence. Oral evidence means, I just discussed, now again I'm repeating. Oral evidence means the testimony of living persons examined in the presence of the court or commissioners appointed by the court. Deaf and dumb persons may also adduce evidence by signs, or through interpretations or by writing if they are literate. Documentary evidence, on the other hand, are to be proved by the production of the documents themselves or in their absence by secondary evidence. Under Section 60 BSA, Evidence Act 65, now it is BSA Section 60. Further facts showing the existence of a state of mind, such as intention, knowledge, good faith, negligence, or ill will, need not be proved by direct testimony. It may be proved inferentially from conduct, surrounding circumstances, etc. Medical witness is very crucial, independent testimony, and it is not merely a check upon testimony of eyewitnesses. The evidentiary value of a medical witness is very crucial to corroborate the case of prosecution, and it is not merely a check upon testimony of witnesses. It is also independent testimony because it may establish certain facts quite apart from the other oral evidence. The medical evidence adduced by the prosecution has great corroborative value, as it proves that the injuries could have been caused in the manner alleged. Now we have discussed about oral testimony, corroborative evidence, primary evidence, secondary evidence, documentary evidence. Now the question arises, at what stage corroborative evidence may be given? What is the stage? Before corroborative evidence is admissible, the evidence sought to be corroborated must have been given. This is the condition. In a case, suppose first corroborative evidence is given, then what will happen? In a case, corroborative evidence given before the giving of evidence sought to be corroborated then was ruled out. I may come across only one citation. If corroborative evidence is given first and thereafter, after some days, if oral testimony is given, then it is not valid. Citation is Muthugondan versus China. Absence of statement of a witness about the assault, the medical report referring to the injury is of no value. The medical report prepared by the doctor is just a memorandum which can be used by him for refreshing his memory. It is not a document. Suresh Kumar and another was a state of UP. 1992 in bracket 2, Crimes 872, Allahabad High Court. Third, it is well established legal principle that unless cause of injury is thrown, mere presence of injury, even if it is there and duly proved, would not serve the purpose. It is well established legal principle that no corroborative evidence is admissible on matter in respect of which the witness whose evidence is to be corroborated himself does not give evidence on the point. 164 CRPC. Now it is BNSS 183. Is not substantive evidence, but it can be used to support or challenge evidence given by the person who made the statement. Why it is not substantive evidence? Question arises. What is the defense? When witness is brought before the court, learned magistrate asks him the question whether he wants to give the statement. Yes, then it is recorded. It is given or not. Still it is not so. Why? Because it is recorded behind the back of the accused. At the time the accused is not present. It is not given during trial, so it is not substantive evidence. It is only for the witness who gives it that he cannot go back. He cannot become hostile witness. He has to give the statement correctly. Court has held that it is clear that identification by finger, touch, node, or assent in answer is a statement expressed or implied and comes within the ban of CRPC section, ban of BNSS 181, CRP section 162. Now it is BNSS 181. So it cannot be considered as evidence. BSA Section 160 does not make hearsay evidence admissible as corroboration. The most important evidence, contemporaneous evidence as per Section 160 is police yadi. Police yadi is a contemporary evidence because when marpit takes place, an injured person goes to the police station, then police officer records his injuries and writes in police yadi. So it is at about the time. History of assault. When injured person goes to the hospital with police yadi and gives a history of assault before the doctor, so that history of assault is not a substantive piece of evidence. Now the last but most important, enmity. Enmity is a double-edged weapon, which can be a motive for the crime as also the ground for false implication of the accused persons. Now, that's all today. Hope you have enjoyed this video. You have got some vital information. If you are new to our video, please subscribe it, like it, and share it. Thank you very much for patient hearing. See you in the next video. Thank you, thank you, thank you.